copyright trademark claim with. So it's very similar to Microsoft. If you get the software, there's agreement. It's called a user agreement. Do you accept the terms and conditions? Yes. You click yes. Then you get the software downloaded. If you say you do not, then there are certain limitations to the contract that Microsoft will allow you to use. I don't know. I've never clicked the do not accept, so I don't know what happens.
Closes the program.
There you go. There you go.
Ends the discussion.
Bingo. So you don't get the software.
Yeah.
Yeah.
So if somebody sends you a letter and they use your name, how do they automatically enter into the user agreement?
No. Then what you do is when somebody sends you a letter, you send them a registered notice and a user agreement.
Giving them a warning.
Giving them a warning, saying you do not have permission to get involved in this matter. Stay out. You're third party. You're not permitted. And if you continue to persist and insist, then yes, you're definitely going to get a bill from me. It's all about contracts, right? So the North Shore Credit Union was relentless and went after me with a lawyer by the name of Andrew Burry from Gowlings, a pit bull foreclosure law firm specializing in patent and trademark law. I fought Burry and his firm every step of the way and paid my mortgage with a Canada banknote described as an international bill of exchange pursuant to the Bills of Exchange Act. I paid my property taxes, Citibank credit card, and CCRA. And to my surprise, CCRA confirmed in writing that an electronic transfer of funds was administered by the Receiver General of Canada.
So that proves the bond works.
Absolutely. That is a definite validation. However, this $59,000 payment was not sufficient. With arbitrary assessments pulled out of thin air, CCRA was determined to send me out into the streets and continued their attacks to foreclose on my home. CCRA approached my ex and took my entire settlement as he wrote post-dated checks to pay off the debt to them. He told me that CCRA threatened to close his resort if he did not comply with their demands, and that would mean sending 150 employees out into the streets. That's what they threatened him with, and he went into fear, so he bought the story. CCRA does not care, and neither did he. All my bond payments were entered into court as exhibits under my affidavit number 2, and you can find that on the record. So anybody who is wanting to validate my claims, just go to the Vancouver Registry on Howe in Vancouver here and just ask the court clerk to view the court case between Gravenhorst and the North Shore Credit Union, and then they'll get a big huge file. Big huge file. Lots of reading. I also presented my bond payments to Justice Silverman in August 2005, and none of my bond payments were returned to me. North Shore Credit Union continued with their pursuit to steal my home away from me and issued a decree nisi despite the rendered CIC bond payments. Now there's a difference between CIC bond payments and CBC bond payments. A CIC bond payment is a Canadian Immigration Certificate bond payment. And that means there's value to the number on the capitalized name. And according to the Minister of Finance, it's issued at $1 million per issuance. I hear that the number is far higher than that, but I don't have any proof of that. I don't have any evidence of that. The CBC bond payment is the Canadian Birth Certificate. So that also has value. Now the ones who benefit from this is Canada Bank, Bank of Canada, Her Majesty the Queen and Right of Canada, anybody working for the government on a high level, they get to actually trade the securities and the value of the bonds on international markets behind closed doors. So I was harassed by couriers day and night with court documents, and it wasn't until the spring of this year when Burry served me with a contract of sale for foreclosure that I decided to sell my home on my own with my realtor, Michael Shellhaas from Remax. Despite the fact that my house was sold, Burry and the North Shore Credit Union wanted to change the locks on my home. I went to court to meet Master Bolton and stated my common law jurisdiction claims. As he literally bolted from the bench in front of over 10 witnesses who supported me, he instructed the sheriffs to take me away. As 5 sheriffs approached me in full uniform with their hands positioned above their guns, I looked at them and said, you do not have permission to touch me. Very clear. They reacted by ushering people out of the court and left me alone while I told Burry that the house was sold, and did he not receive my fax that the $40,000 deposit to secure the sale was held in a trust account with Remax. Burry avoided me and would not look me in my eyes. I received an unsigned court order from a courier, and then one evening the banker and the bailiff and locksmith came to my house unannounced. They presented me with this unsigned order and attempt to change the locks on my home. As we discussed this document with the RCMP, my witness videotaped the entire experience. The RCMP officer did not want to be there, while Prudential, the real estate company acting on Burry's instructions, insisted that the document was valid. I said, no, the document must be signed by Master Bolton, because I stood in front of him to make my claims and to tell him and inform him that the house was sold. And I have that also in an affidavit number 9. They promised to return, the bankers and the gangsters. The RCMP, banker, bailiff, real estate agent, appraisal showed up again, and the locksmith 2 days later, and this time I was supported with 3 video cameras. Stan, Paul, and Radar videotaped the entire proceedings. This intimidated the 2 RCMP officers who eventually left, for they could not create a joinder of me, the flesh and blood woman who stood before them, as name to the capitalized name, for I claimed that I was the agent. I'm the agent for the capitalized name. So as the agent and as the creditor for the capitalized name, also as the author for the autograph of the capitalized name, and the copyright and the trademark laws come into effect, which are international treaty laws, someone has to pay attention, right? I had faxed all my notices to the 3 judges about my experiences, and I believe that what sealed and stopped the further harassment was a notice of appointment. Really important document. This notice of appointment appointed the RCMP officers sheriffs from municipal, provincial, and national levels. And I had already initiated this document by sending these particular sheriffs and RCMP officials about CCRA's conduct, because I had charged CCRA with criminal harassment and criminal charges. In summation, everyone who laid claim to my name without my permission is in contract with me, for no one has permission to lay claims to my name, as it is copyright, trademark name protected. International treaty law does not require registration. You merely declare this and state the value of the infringement per use. Justice Chamberlain is given credit for helping me understand the power of trademark claims. And no, he is not in contract with me, because he gave me that valuable tidbit of information when I appeared in front of him. I must now find equitable remedy by estoppel to appoint a third-party fiduciary trustee to monetize the value of the contracts that names me as the creditor and them as the debtors. And this is a problem. The reason why it's a bit of a hurdle is because no insurance agency wants to insure these named debtors, for they are now a liability to the system. Mr. Burry, all of the judges who are in contract with me are going to have serious problems renewing their contracts, because the insurance companies know that I have a claim against them, and it's for millions and millions of dollars. The problem with CCRA is that I have nothing in their jurisdiction, and as they continue to lay claims on me, they continue to increase and incur a further debt. It's a real serious problem for them, because I mean what I say. It's like a promise. I make a promise to you, Paul, right? And if I make that promise, I'm going to keep that promise. So if I make a promise to CCRA that I've copyrighted and trademarked my name, I have to be diligent